before you get to the main. This is gold, but. Right. What I hope that is going to be, but, and then we judge with that. All right. Court of Appeal and for the sixth at the state of Florida now that Honorable Mary Narvella, judge, presiding. All persons having been before the court draw near and give attention, and you will be heard. And God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. Welcome to an oral argument session of the Sixth District Court of Appeal. As our marshal said, my name is Judge Nardella. Joining me on the panel today is Judge Wozniak and Judge Brownlee. We have one case for our consideration today. It's 24-0237, Paul Faraday versus the state of Florida. Each side will be permitted 20 minutes of argument. Counsel for appellant, we typically reserve 5 minutes for rebuttal, but if you'd prefer a different increment of time, please let us know whenever you're ready, counsel.
Thank you.
Good morning. May it please the court, Michael Lefferman on behalf of the appellant Paul Faraday. And I would like to reserve 5 minutes of my time for rebuttal.
Thank you, counsel.
I'm hoping to address both of the claims raised in the briefs, and I'll begin with claim number one, and whether the trial court erred by granting a new trial after it was discovered that the foreperson had engaged in misconduct or had failed to truthfully answer one of the questions on the jury questionnaire in this case. There's a lot of layers to this claim. I'm going to jump in and discuss the three-part De La Rosa test, but of course, I know the court will redirect me to one of the other layers should the court want to inquire regarding those other layers. I will be.
Your position is that De La Rosa applies, not the higher post-conviction standard.
Well, right. This is not in a post-conviction process. You hadn't been sentenced yet, so there had not been a final judgment.
Okay.
Under De La Rosa, it's a three-part test. Number one is the information relevant or material to jury service that the juror failed to disclose. Number two, was it concealed by the juror? And number three, the failure to disclose must not be due to want of diligence by the complaining party. I've argued in my briefs, I'll argue this morning, I believe Mr. Faraday establishes each of those tests. I think and there's different layers to each aspect of the test, but beginning with whether or not the information was relevant or material to jury service, I think counsel below said it best, and this is pages 659 and 660 of the record. He said it's pretty clear that this case wasn't just about the nature of the charges. It was also going to come into evidence that my client was in a same-sex relationship, cohabitating together with a gentleman who turned out to be a witness, one, and two, the alleged victim's brother. So it's pretty clear at that point that if a juror had made it clear that they were the victim of a domestic violence situation, lived together, domestic violence, dating, whatever it may have been, any defense lawyer would have stricken that juror right away. And he went on to say, but in any case where there was some domestic relationship that was going on that was going to come out of trial, you would not want someone who had that bad domestic relationship as a juror. So I believe that.
Did he ask the other jurors about whether they had ever been victims of domestic violence?
He didn't need to. It's interesting in this case, and I've handled a handful of these cases around the state, and they're all a little different. Some have questionnaires, some don't. This case, we kind of have a quasi questionnaire and going over the questionnaire and questioning with the jurors. So the questionnaire just asks, and it's question 18, have you ever been the victim of a crime? You or a family member have been a victim of a crime. This foreperson said no. However, when the jurors introduced themselves during the jury selection process, each of them went through the questionnaire. Now, notably, this foreperson did not. She skipped over that question and didn't give any answer about that. But the other jurors, they would say, I've either not been a victim, or if they have been a victim, they all specified what they were a victim, what crime they were a victim of. So the record is very clear that there were a number of jurors who had been victims of crimes. And if I could just go through those, I can give you the names. I won't right now unless.
Are any of them related to domestic violence incidents?
None of them were victims of domestic violence. Home burglary, robbed, home burglary, house broken into, car broken into. We do have a couple. One was a daughter was raped, and that juror was stricken by agreement of the parties. We have another juror who was a victim of sex abuse. That juror was also stricken by agreement of the parties. Mr. Day, defense counsel, being involved in that discussion, saying that would not be a proper juror.
Counsel, is there any evidence that at the time that the juror answered the question that she was aware that she was a victim of a crime?
So I don't know the answer to that, but I do.
No. I'm not asking you to speculate. What I'm asking is there any evidence in the record that would suggest that she was aware that she was the victim of the crime? And you had a chance to interview her.
Sure.
Right?
Yes.
And as a result of that interview, did it come across that she was aware that she was a victim of a crime at the time she answered that question?
But the best example would be her petition for domestic violence injunction, where it specifically says, like, forward to the page. when she gives her narrative right before it, it asks, have you been the victim of a crime? And she specifically checked yes. She checked several boxes indicating that she'd been the victim of a
But
crime.
she did that after consulting with counsel, and according to her interview, that consultation didn't occur until after.
That's correct.
Correct? So at the
Correct.
time that she gave her answer, is there any evidence that she was aware?
But so let me answer. I
I
don't,
understand there's going to be a legal component to that answer, but
yes,
just as a factual,
that there's no evidence one way or the other whether she was aware at the time. I don't think she was, she did not disclose that I either didn't realize that was a crime or thought that was a crime. But more importantly, in the Roberts case from the Florida Supreme Court, it's cited on page 26 of my brief,
right?
a juror's non-disclosure need not be intentional. So her subjective thought as to whether or not she was a victim of a crime is irrelevant.
Well, my
Shouldn't it-
question is, how does that interact with the other rule that if you have a requirement to be diligent and follow up? And this is what I'm thinking. When I read, I forget if it was Roberts, it may have been another case that came from the Florida Supreme Court, but it also confronted somebody who was a victim of domestic violence and their specific answer to that question. And they also did not indicate that they were a victim of a crime. Are you familiar with what I'm talking about?
I am, yes.
Okay. And it suggests to me, and I think it may suggest to all counsel, that there is a widespread, not a narrow, but a widespread failure to apprehend that being a victim of domestic violence may also mean that you have been subjected to a crime.
That may be true.
And if that is true, if that is widespread, does that not put an onerous on your client to ask more detailed questions than to just let the questionnaire go?
So
You see what I'm saying? Yeah.
I mean, that would obviously somewhat defeat the purpose of a questionnaire, because then counsel would have to ask every single juror who's already filled out the questionnaire and gone through the process at the beginning when they introduce themselves and talking about whether they've been a victim of a crime. And so many of them said that they have been.
Right, but all of those answers were obvious, right? I've been robbed, I've been mugged, I've been carjacked. You know you're going to get those. But are you going to get something of more personal nature, which is inter-family crimes or violence, for which is very important and material in your case, you're
Sure.
telling me? Isn't there some suggestion out there from the case law that you're not going to call that information from that question?
I don't know. I don't know that that's the case. I think, have you ever been a victim of a crime? And she says for the last 6 weeks at least, I've been a victim of stalking. I think the normal objective person would know that stalking is a crime. I think we clearly, from a legal standpoint, stalking is a crime. So the answer to the question was incorrect, whether intentional or not. She still gave an incorrect answer. So for defense counsel then to have asked every single juror, and there were a lot that they went through in this case, hey, I know we've already asked you in question 18. I know you've already gone through and answered, but let me go one step further and say, I know you said you weren't a victim of a crime. Maybe you don't know what a crime means. Do you understand that domestic violence would be a crime? Have any of you also been a victim of domestic violence? If that's what you're suggesting that counsel would need to do in a case like this, obviously that wasn't done. And I submit that that's a step too far. What's the point of having the questionnaire if counsel cannot rely upon, as counsel did throughout this entire case, the 3 jurors who indicated that they had, that they themselves or had family members that were victims of sexual abuse, they all were dismissed by the agreement of the parties. I can understand why counsel wouldn't dismiss the jurors that were a victim of a burglary 10 years prior. But as Mr. Day explained below, this was a domestic situation and he had a right to rely upon this 4-person's answer when she said no.
Does
So-
her intent with regard to her answer no matter for purposes of the jurisdictional time frame and granting a new trial? I mean, isn't that like sort of a separate question? Like, how are you going to get through? And I understand there's a rub between the 2 rules, but if you're going to ask that trial judge to grant a new trial
There's
out
some
of
problem.
time,
Yeah.
then doesn't it matter if the testimony is false or fraudulent? And like with regard to her intent is what I mean?
No, I mean, of course, my answer is going to be no. I don't think we have to charge her with a crime for a court to apply the fraud on the court motion for new trial exception. I think the fraud on the court, even in the Glover case, has more of a general context. In this criminal setting, should we allow what we now know to be something that's untrue to prevent the defendant from being able to move forward with this claim? And the 50 CA and Glover said, no, we're not going to allow that. So in a situation like this, again, I don't know where the trial court actually came out on this, but I feel confident telling the panel today that she didn't tell the truth from a legal standpoint. She didn't tell the truth from an objective standpoint. Whether subjectively she realized that stalking and the other things she's alleged in her petition amounted to a crime or not, again, that's irrelevant as to whether or not there's concealment. Bless you. But she didn't objectively. We know that, and therefore that is a false answer, and that does fit within the fraud on the court exception. And I've also argued from a
But you're
policy.
saying fraud. Fraud on the court sounds different to me than just answering innocently. And I understand the case law and with regard to intent. But if you're saying fraud on the court, that to me is something more nefarious than just answering a question incorrectly.
I understand that, and
Do you
obviously
agree with that?
I think the crime of fraud, if I was representing a defendant who'd been charged with fraud, the state would have to prove intent. I don't disagree with that for a second. I think fraud on the court as being used in the Glover case is more general. And was there false information provided to the court that would allow the court to exercise its judicial authority to find an exception to the otherwise applicable 10-day jurisdictional time period? And I think that also fits into the time scheme. It is interesting that the Rules Committee and ultimately the Florida Supreme Court in adopting these two rules, clearly the remedy in the cases I've cited in my briefs, I don't think the state disagrees, the remedy if you do establish juror misconduct is a new trial. That has to be the remedy. And yet
Is
3 point.
appealable? Is an order under 3.575 independently appealable?
No, I don't believe so.
Okay, but it's completely, do you think it's completely independent from 3.590, or do we read them together?
I think you have to read them together. I think, again, because the only remedy for juror misconduct is a new trial. I can't imagine any other remedy that a judge would grant if it's established that a juror did in fact engage or gave a false answer that prevented a defense attorney from exercising a peremptory challenge. So in that context, when 3.575 allows the good cause exception to the 10-day time period, and the judge finds it, as in this case, and then it's established, as I believe, that we have a situation where a juror did in fact answer question 18 incorrectly, falsely, whether she
So
intended.
the trial judge really finding good cause in this case for purposes of setting aside the time frame, or do you think that the court was saying it looks like there's enough here to think she might have answered something incorrectly or falsely or fraudulently, and therefore we're going to have that second hearing? Because it seems to me that it was presented that, well, we don't have transcripts. Well, there are a lot of sort of time issues with regard to the timing that I'm not sure would have truly precluded the defense from discovering this information.
Well, so let me just read you what the trial court's finding was.
Thank
This
you.
is page 616 of the record. And this is quoting from the trial court. Here it appears that the unrefuted testimony from Mr. Faraday is at the beginning, within the 10 days he attempted to line up appellate or post-conviction counsel, there were efforts made when he was able to use communication mechanisms within the jail on his own behalf, also through his family. There was regular communication with a person named Mr. Upson. There were at least 3 visits with Mr. Upson, and eventually Mr. Faraday terminated Mr. Upson. Given the important stakes for both Mr. Faraday and the state, and given that Mr. Upson has not been presented as a witness, I can't find anything definitive into Mr. Upson's failure to file a notice of appearance, but it does appear to be unrefuted that Mr. Upson was contacted and he made representation to Mr. Faraday that he was going to pursue, and they were earlier discussing a jury investigation, and he failed to do so. So under those circumstances, I will find good cause and allow the motion to go forward. So I think he made a very specific factual finding based on the testimony from Mr. Faraday at that hearing. The state did not put on the previous appellate attorney to refute it. And Mr. Faraday said, look, from the moment I initially had a delay when I got to the jail, I couldn't have any communications. Once I did, I immediately reached out to this new attorney. He came and saw me within the 10-day time period and said he was going to pursue this. And lo and behold, he moves to another town. He orders the wrong transcripts. And in light of all those circumstances, Mr. Faraday, through no fault of his own, was unable to get this done within the 10 days.
Thank you.
That's what the judge found. And again, I think that's a quasi-factual finding at the very least. And I don't know if there's any, I think there's substantial evidence in the record to support that. So where are we? Again, at the end of the day, I think we do have a valid basis for good cause. I think when it ends up being established that there was false information that a juror is given, regardless of whether it's intentional, that there has to be a mechanism pursuant to the Glover case to allow a remedy after the court agrees that there's false information. And in applying that to this case, when you use the three factors, again, Mr. Day was very thorough in questioning several witnesses. I want to point out just quickly, the state talked about juror Kawaki on page 473, who indicated that there was someone in his background who'd been sexually abused. Mr. Day went through a thorough examination of Mr. Kawaki, and ultimately Mr. Kawaki was never selected. His name never came up. So again, none of the jurors that were selected had any type of domestic situation where they were the victim. There's another juror who said that there was a family member who was charged with a domestic situation. That's different from being a victim. All of the jurors who were selected, even though they might have had been a victim of a burglary or some other type of crime, it was not anything that would preclude them from being a good juror for this case. And the three that did have that background with sexual abuse, all were stricken. Let me quickly move to the second issue. This involves the state's witness, Zernobi, who testified. So a child protection team interview was done in this case, and I see him in my rebuttal time. I'll hopefully take about a minute on this. A child protection team interview was done in this case, but because at the time, and the law's now changed, and you can be 17 and still introduce under 980323 17-year-old's testimony, but that changed in 2024 after the trial in this case. But at the time of the trial, the statute said 16, and at the time of the interview in this case, the alleged victim was 17. So everyone agreed that the child, the audio portion of the interview could not be played for the jury as if it was a normal child hearsay exception case. However, the person that conducted the interview was nevertheless presented by the state as a witness. And she said that based on her interview, based on her interactions with the alleged victim, she made these three following conclusions: that he was reality-based, that he had not been coached, and he had no motivation to lie. They went one step further, and the state said in their answer brief that Zerbini did not give an opinion as to alleged credibility. I would note, page 201, she did pretty much say that. This page 201, an answer to a question: if I find the child is uncredible, we wouldn't be here today. So she is definitely letting this jury know that based on her interactions with the interview that the jury doesn't get to hear, she's made all these conclusions. Those are substantial conclusions. What I just read, we wouldn't be here today if I didn't find that child credible. That's substantial. At that point, the door was opened to allow the jury to see exactly how the alleged victim was behaving during that interview. It may not have come in otherwise, but if you're going to have, the state's going to put on an expert and say that based on my interactions with the alleged victim in that interview, I was able to come to these conclusions, the jury should be able to see just that, what she was looking at and what would have caused them to come to that conclusion.
But
And
wouldn't it have been somewhat confusing for the jury to sort of just see half of it? And you can call it whatever you will, but and I understand the audio portion doesn't come in because of the hearsay problem, but to just allow the jury to see mannerisms and someone explaining something. I mean, what about this requirement that we don't, for lack of a better way to put it, but we're not going to confuse the jury. We can't do anything that's misleading to them.
I think it's extremely confusing to a jury to have someone who's not an expert get up and say, I found this child was credible. And what is she basing that on? So the jury has a right to see exactly what it is she's basing that on.
But
That's
they
all.
wouldn't know what they're talking about. They could be talking about the weather in this if the sound is going to be.
I understand. So I think the judge could have said, look, you're not going to be able to hear. It's impermissible under the law for you to be able to hear this interview. But nevertheless, this is being introduced for the purpose so you can see exactly what Ms. Zernobi saw when she did this interview in reaching these conclusions. I think that type of instruction to the jury could have helped them. And then, of course, defense counsel wanted to be able to argue in closing as he proffered, look, this is a child or an alleged victim who's acting relaxed, arms crossed, feet on the table. This is not someone not the mannerisms you would expect from someone who is disclosing this type of sexual abuse. And the defense was deprived that opportunity by not being able to have that video shown. And again, maybe it wouldn't have been able to be shown outright in the defense's case in chief, but for the state putting on this is an unusual witness. Usually you wouldn't have the child protection team interviewer testify and not actually play the interview, just get up there and say, these are things that I found based on my interactions. Once that happened, they chose to do that. The door is open. The defense can't be at at a disadvantage because they chose to put up that witness to say that without being able to then show the jury what she actually saw in forming those conclusions and be able to respond to it, just as I said, Mr. Day would have been able to respond in closing argument. Let me reserve my remaining time for rebuttal. Thank you.
Good morning, may it please the court, Wendy Buckington on behalf of the state council. Briefly, I'd like to address the finding of credibility because that testimony was elicited by the defense counsel. He did not ask to have the court strike it. It was not elicited by the defense. There was no objection to any of the CPT interviewer's testimony. There was no preliminary motion in limine to exclude her testimony. And when she did testify to what does say that if I didn't find him credible, we wouldn't be here, that was elicited by defense counsel, and he didn't do anything about it to move to strike it. He merely cross-examined her. As to a couple things that were asked, we do dispute that the potential juror was not credible. I mean, I'm sorry, that she was not honest and truthful in disputing. I'm sorry, my leg is like shaking. I'm nervous. But anyway, but about being a victim of a crime. Now, her petition does indicate that she had called the police several times. The record does not show that anybody was arrested. So there was no reason for her to construe the conduct that her husband was subjecting her to as being a crime.
Can I ask you to jump to sort of the intent element of this? Counsel has posited pursuant to case law that it doesn't matter for purposes of the timing requirement or for establishing entitlement to a new trial, whether she was purposefully dishonest, can you just address whether this was sort of inadvertent or intentional and how that affects the case?
I think it affects the case in the sense that there isn't this, I mean, there is some broad language in the Glover case regarding fraud on the court, and it cites Burton, which talks about the common law and judgments being void ab initio based on fraud, but there isn't this motion for new trial fraud on the court exception articulated in Glover. It's really very narrow. And in looking at it, it talks about a court being able, and I do want to quote the language exactly so that I do not misrepresent it. So, and as we recall, the timing, right? We have a timely filed motion for new trial. We had a timely amendment to that motion for new trial, which the rule provides within 10 days, you can file your motion. Within 10 days, you can amend without leave of the court. And then after that, you need to get leave of the court to amend your motion for new trial. And in Glover, there was a motion for a second amended motion for new trial filed after the 10 days. Now, the motion for new trial was then denied, and then a motion for rehearing was filed, denied. I'm sorry, and also there were affidavits an affidavit submitted with a second amended motion, motion to file a second amended motion for new trial. There was an affidavit there. Denied, motion for rehearing, denied. Second motion for rehearing with another affidavit from another witness attached. And at this point, it was granted. So now the state appeals, and on appeal, the court says the question in this case is whether false testimony given against a defendant. So again, it's false testimony. It's not the non-disclosure of information, material or not material by a juror.
It's just incorrect.
Correct. You mean for the juror?
Yes, to what you're pointing to.
Oh, I'm pointing to false testimony in a criminal proceeding.
Yeah.
So the issue is false testimony, whether it constitutes the kind of fraud referred to, and it talks about the Burton and a couple other cases, and this is the critical part, I think, as allowing a trial court to reconsider its ruling on an order despite the apparent loss of jurisdiction. So there was jurisdiction, timely filed motion for new trial. There was the loss of jurisdiction once the court ruled on it because there's no authorized motion for rehearing. But the court says when that first order is based on fraud on the court, and in this case, the fraud on the court, this case meaning the Glover case, was the testimony by state witnesses if they believed the affidavits that had been submitted with the motion for new trial and the motion for rehearing, then that court should be able to reconsider its decision. And the same situation was in Burton, where it's that they relied on here. It's the reconsideration of an order that the court has entered based on a finding of fraud on the court. So there is no fraud on the court exception for filing a motion for new trial that's been cited in the brief so far and that the state has been able to locate.
What are we to make of the tension between the two rules on the motion for new trial requiring the 10-day time frame, and then the rule with regard to interviewing the juror, and the good cause exception set forth in that. So once we have our trial judge here saying, well, he's finding good cause,
Right.
you know, to extend that time frame. I
Right.
mean, could there then be any remedy in your theory of the case for if indeed, say there was something really bad, like we know for a fact based on the evidentiary hearing that ultimately came about that she purposefully defrauded the court, it was bad, she perjured herself. Could, under your theory of the case, could the trial judge in that moment, 104 days later, ever grant a new trial?
No,
What do we do about those rules? How could that be?
we'd have to have the rule changed because we also know that the rule 3050 that talks about expanding times, it specifically accepts you cannot expand the time for a motion for new trial, notice of appeal, or motion for judgment of acquittal. So that rule is, you know, indicating you cannot extend that time for motion for new trial. It's jurisdictional. The recourse, and Mr. Faraday is not without recourse, except for on the merits. He was not successful anyway, but is a post-conviction motion, a 3850, when it's discovered later. Let's say it was something that was very critical, like this victim held back the fact that, you know, perhaps her child had been sexually abused, perhaps she had been sexually abused, and that it was an intentional lie to the court in selection in order to serve on the jury. That, and when it is discovered, if it's after the fact, it is a motion for post-conviction relief.
But is there an argument that it could be procedurally barred here because it was discovered before the judgment and sentence were entered? So it's kind of a weird black hole area.
Well, this court's opinion would need to show, as the case in Dessa did, it's dismissed if there's nothing else raised, or it's affirmed without prejudice to raise this in a 3850.
Okay.
So it's clear that it hasn't been ruled on, because looking at the briefs, and if you didn't have that language, it would appear to be ruled on and then subsequently procedurally barred. So the fact that the rules, there is a discrepancy between the rules, but the cases that have granted relief, there was a timely filed motion for new trial. And here, this information, I think the judge was being generous in granting the hearing. This information was available, his court records. It showed that the time from when the company was hired to investigate the background of the jurors and the questionnaires, that was 9 days past. This is something that could have actually been timely brought in a motion for new trial if it had been acted on. A couple other things that had come up regarding argument and questions by the court. Yes, Judge Brownlee, you had asked, did he ask about domestic violence? He did not ask anything about domestic violence or injunctions of any of the veneer. And to the one juror, Juror L, who did disclose her father had been arrested for quote unquote domestic, which is the same language that is used by the juror when she discloses about the hardship. She calls it domestic separated. There was no follow-up with Juror L. Domestic situation separated is what she said. There was no follow-up with Juror L regarding the fact that her father had been arrested for a domestic situation, regarding what that was and the fact that it's her father. And I know Mr. Upperman had talked about that in that case, it was someone that was accused of a crime, not being a victim of a crime. But if it's domestic situation and it's your father, you know, it's certainly inherent the possibility that that juror was also a victim of a crime.
Counsel, what do we do if we find that there was no notice to the defendant? The defense counsel was reasonably diligent and that the juror did not intentionally conceal it?
I think we are under the De La Rosa factors of, and Lugo gives us the example, which is very parallel regarding the battery that happened at work. So he, in that case, disclosed that he was the victim, similarly on questionnaires, I believe, victim of theft. He did not disclose that he was the victim of a personal crime, a battery. He didn't think of it as a crime because there had been no arrest. It was a workplace situation. And the court found there that there was at least an ambiguous situation that counsel was obligated to follow up with and didn't, so did not satisfy the due diligence aspect of the De La Rosa test. So for the three parts, Mr. Faraday satisfies none of them. Number one, was it material and relevant? We know it wasn't because of the lack of questioning other jurors about a domestic situation, any family issues regarding the fact that there was the pattern of questioning, which also goes to material and relevance. This was not something that was investigated by the defense. Regarding the fact that the disparity of the charges also goes to material and relevance. The disparity of the charges of allegations in a civil petition for an injunction against domestic violence as part of a divorce, that she was clear at the hearing. This came after the fact. You know, the process was going on. She was separated, but the actual consulting attorney and moving forward came the Monday after the Friday verdict. And that, in Lugo, it says the disparity of the workplace incident and extended torture and captivity of the victim conclude us to that it just was not relevant. And here we have the disparity of an ongoing divorce, no action yet taken, harassment and stalking, not used in the legal sense. Those are crimes, but elements have to be proven. And that is not any indication of that level of harassment and stalking here, because we know the police were called. No one was arrested according to these records, and the victim would not have thought of herself as a crime. And then to the crime of a lascivious molestation and battery on a teenager, there's just a disparity in the nature of those crimes. What else I thought was important?
Counsel, is there anything to be made of the fact that there's a difference between a crime that happens in a moment and a crime that happens over a course of conduct? For example, stalking typically requires 2 acts,
Okay.
right? So when the ability to pinpoint when a crime occurs for some jurors may be different from others. Is there anything to be made of that in our analysis?
Well, she clearly was under pressure. You know, she was in fear of what might happen. The fact that it's ongoing, you know, when she said she called the police, I believe it's in her petition, it indicates that was for advice. She called this shelter and the police for advice on what to do. Apparently, they didn't feel they could do something. The fact that it is ongoing versus her awareness of it being a crime, is that the question? That
I guess I see the awareness as being affected sometimes by the nature of the crime and whether or not it's something that requires additional incidents. I didn't know if the state.
If I understand Your Honor's question, it's the fact that maybe like a single battery, you would maybe should know that that's a crime. Compared to you get used to the conduct. My husband is kind of nutty.
Well, not just that, but you read her petition. It doesn't strike me that you can read her petition and say, right here is when a crime occurred.
Okay.
Right? It's a totality.
Right.
It's going to be taken into consideration by the court.
Right. And I don't believe there has to be an actual crime for the petition again for injunction against domestic violence, which is to happen in the future. It could have happened in the past and happen in the future.
It's more unique than the examples that the other jurors gave, I guess is my.
Yes, it's certainly more nebulous, right? Regarding whether I think like if I've been burgled or my wallet stolen, I understand that as a crime. So, so it would be, definitely she did not think she was the victim of a crime because she was not, apparently by the questionnaire, did not seem to be holding back. She disclosed forthright about the domestic situation as a quote unquote hardship, which typically we would think of that as being more like a work hardship or health hardship. But she felt it was a condition that she wanted to disclose that was going on in her life. And so she wanted to disclose that. But she definitely did not think of herself as the victim of a crime to be concealing it based on her answers, based on anything that came out at the hearing, which was very narrow. She was not asked about why she didn't say yes to that question. I think she just was, forthright. We don't have any evidence that there was a crime and regarding the language of harassment and stalking, which can be crimes. There are elements, they have to be proven. Just the fact that we are using that language, I don't think indicates that she was a victim, certainly did not feel she was a victim. Have I fully answered the question regarding the difference of time between the two rules? There being good cause for granting a belated motion for juror interview versus the rule on motion for new trial being limited?
I think so, and I appreciate that. I think that in the state's view, there's just sort of no way to reconcile those two concepts. The problem that there's a jurisdictional problem with regard to granting the motion for a new trial, and then the good cause exception set forth in 3.575. So my understanding is there's just sort of nothing we can do about it in the state's view. And that
Right.
Glover might seem to suggest this sort of fraud on the court exception, but it
Right.
doesn't set forth a true fraud on the court exception. I think,
Definitely.
I mean, I understand that's the answer you gave me. So if you had any further thing on that, but otherwise I'm satisfied that that's your answer.
Do you feel there's any fault in that answer? I mean, is there anything else
don't.
you feel needs to be addressed?
I mean, I have no further questions with regard to it.
Because I think that to reconcile the two rules, there would have to be a change in the rules from the Florida Supreme Court, who, grants jurisdiction, who delineates the jurisdiction through its rules. So,
Do you think, so, I mean, I think that we see fraud exceptions in criminal cases frequently. I mean, not frequently, right? But I think that that's often an exception that we see. And in particular, I could think of it in the context of a 3850. So, if typically those are barred by a 2-year time frame, but now I've got a fraud problem, that seems to matter in case law. So I don't know is it jurisdictional in those times or not, and that makes it unlike this. I don't know.
you can get an extension for the 3850 for filing a fraud claim. I read something regarding, I don't remember the basis of what it was, but where it could be raised, maybe it was the jury interview issue, 2 years after your 2-year limit. I mean, it wasn't limitless. And I might be wrong that that was the specific context, but
Yeah, and I don't want to get far afield from what we argued here, but you were asking me about the fraud. And so, yeah, with regard to the 3850, if you're saying that's truly a remedy that he could have in this case, and Judge Wozniak's question was, well, what about the problem that we didn't have the JNS issued yet? Is that a problem for the trigger date for a 3850? Because otherwise, if those two rules are irreconcilable and you did have, what if you had something bad, right?
Right.
And someone had perjured themselves,
Right.
then is that person foreclosed because the rules, are incompatible and then the JNS wasn't filed yet? And so there's some trigger date for the 3850, or is it just the 2-year cap at the end that would matter?
It's the 2 years at the end after the mandate from this court. I believe it's the mandate that comes out from this court is when the 2 years starts to run. He's already had his interview, but potentially, if there were some other issues that are unbeknownst to him that come up regarding that would all be raised in the 3850.
Regardless of whether he could have found that before the JNS was filed.
JNS, we're talking judgment in the Senate.
Correct.
Regardless of whether they can find four judges.
Like, because Judge Wozniak's point is, well, if that took place before, would he have, because you're telling us the remedy is 3850, if
Right,
anything, and I
right.
understand you're not conceding that, but,
Right.
do we have a problem if he knew about that, after verdict, but before judgment is entered?
Well-
I don't know if we do or not.
If there's something out there now that has not been raised and he does know it, that would be a problem for him. But for what has been raised, it is a matter of it wasn't timely raised, and you would affirm without prejudice to raise it in the 3850.
Okay. Thank you for that.
There are no further questions. Would ask you to affirm the judgment of sentence. Thank you very much.
Hey, please, the court, hoping to make a couple of quick points. I'll begin with the 3850 issue. With the elephant in the room is if a defendant is able to show good cause and a judge, as found in this case, believes that there's good cause and allows the 3.575 procedure to take place, presumably prior to sentencing, like it happened in this case, what happens then when the judge holds the interview, the judge concludes, I understand there's a dispute in this case about what the judge concluded, or obviously the judge didn't rule in my favor, but if the judge concludes that there's juror misconduct, that the judge can't do anything at that point. And then to say that the answer is 3850, well, 3850 brings into a new standard. We know after the Florida Supreme Court's recent cases in Martin and Caratelli, that in a post-conviction motion raising juror misconduct, you have to show that an actually biased juror sat on the jury. So a defendant who does show good cause shouldn't have that additional burden by having to raise it in the 3850. He should be able to be able to rely upon 3.575 and get relief under that basis. I see that my time is up. Thank you.
I want to thank both counsels today. This was well argued and well briefed. We are in recess.